And he arrived in Australia in December 2000 without a passport, because Palestine is not a state and issues no passports. And so he was thrown into detention. He took his claims through the Refugee Review Tribunal, and the claims were rejected. And he then made a separate application to the minister to remove him from Australia and return him to his country of nationality. Kuwait wouldn't have him, and Israel would not allow him to pass through its territory to get to Gaza. And so his contention was a fairly simple one. He said, the Migration Act of Australia has been drawn on a basis that a person who is in detention can end the suffering and be removed from the country immediately by asking the minister to return him or her to the country of nationality. And that is what this man has done. And the principle on which the Act is drafted is the principle that you can finish the suffering by doing what Mr. AlKhatib has done. And so the parties came up to the High Court of Australia, the Solicitor General of Australia, a great lawyer who is here tonight, Dr. David Bennett, a fine lawyer who has had outstanding success in cases before the High Court and who was doing his duty in presenting the case. They came to the High Court, and Mr. AlKhatib had two arguments. The first was, construe the statute down so that it doesn't apply to hold me in detention, potentially indefinitely, because Israel won't take me and Kuwait won't have me. And therefore, the Act doesn't deal with my case. It wasn't drafted to deal with my case, and therefore you can't hold me in detention because there's a strong presumption that you don't construe an Act of Parliament so that it will apply to take away a person's liberty indefinitely. And secondly, he said, and if the Act can't be construed down, and if it does provide to keep me indefinitely in detention, then that is something that a minister can't do, that the executive government can't do. That is effective punishment, and that can only be done by the courts of the land. And the power to Parliament to enact the law, providing for detention, has to be subject to the provisions for the courts in Chapter 3. And therefore it's invalid, and therefore I must be allowed to be released immediately. And so that issue, those two issues, came to the High Court. I wrote what was for me a brilliantly short and pithy decision. I mean, it was 7 paragraphs. Lawyers present will know that my reasons for judgment, though wonderfully lucid and useful and helpful, are not noted for their brevity. But the result of the matter was that the court divided 4-3. Chief Justice Gleeson, Justice Gummow and I said, read the statute down, and Justice Gummow and I said, and if you can't read it down, it will be unconstitutional because the executive can't impose what is effective indefinite punishment. The majority said, what is so difficult about construing a statute which says remove as soon as practicable, and if it is not practical to return Mr. AlKhatib to Palestine, then he has to be kept until it is practicable. And in the end, with Justice McHugh saying that this was a very tragic case, the majority, by 4-3, decided that Mr. AlKhatib could effectively be kept indefinitely. Fortunately, immediately prior to the last election, the minister in the outgoing coalition government decided that Mr. AlKhatib should be released from detention. And fortunately, he received assistance then and before then from many Australians, fine lawyers who had been supporting him and many others during his detention. He, 2 weeks ago, on the 7th of February, was made a citizen of Australia. Now, Ahmed Ali AlKhatib is here with us tonight. He is a person who used every legal endeavour, as was his right, and he went through the hierarchy of the Australian courts, as is rather unusual. I'm told that his ceremony of admission to Australian citizenship was marred a little by the fact that the official who was present at the time was, shall we say, not entirely sober. But I want to tell you, Ahmed, I want to tell you that you are now a citizen of a free and fair country that lives by the rule of law, that the judges who decided against you were doing what they believed the law to require, that the judges who decided for you were doing what they believed the law to require, that it is part of the price of a rule of law society that you have to have decision makers, that they act according to their conscience and to their understanding of the law, and that the wonderful thing I can say about the rule of law in Australia after having been a judge for 34 years is I never once had anyone try to pressure me to decide a case one way or the other. No government official, no big end of town, no powerful corporation. Occasionally Mr. Murdoch or the others would give a bit of help in their newspapers, but this is a country of independent judges, and in the end, through a combination of decisions of the courts, of decisions of elected politicians, and decisions of good Australian citizens to stand with you in what they saw as a human ordeal, you have been accepted into our midst as an honoured citizen. And I want, on behalf of everyone present, to say welcome to our citizenship, congratulations, and we honour you as an Australian citizen. Now, the controversy about the use of international law arose in that case because in my reasons I had referred to the use of the international principles to help to come to the conclusion both on the meaning of the statute and on the meaning of the Constitution. And more recently, in a very important case, most of these cases are fought pro bono by lawyers who are not in it for the mullah, who are in it for the principle. And this case involved the rights of prisoners to vote in our elections, and brought by an Aboriginal prisoner who said, I may be in prison, I may have committed my offence, but I'm still a citizen and a human being and still entitled to vote. And the High Court, in a decision which did refer to international authority, as will increasingly become necessary in a world where we're all interconnected with the internet and with the knowledge of what is going on, and we don't need to reinvent the wheel. This is something which is natural. Scientists regard it as a non-issue. Business people regard it as non-controversial. Lawyers have got to grow up and see that this is just the world we're living in, that globalism is part of the world, and that involves trying to make our little jurisdictions, even in sunny Australia in the South Seas, fit into and coalesce with the principles of international law and international fundamental rights. So that's really what I came to say, and I'm very grateful for all of you coming to hear me say it. And now is your chance to ask questions, to make comments and give criticisms. And I am going to provoke them, and if you don't ask a question of me, I'm going to ask a question of you. Are there any questions? First of all, you can give a big round of applause to the Speaker. All right. I don't want to get carried away by this. Any questions or comments? Yes.
Thank you, Michael, for that lucid speech. As someone who's advocated the liberal tradition of tolerance here at the university and through your career, I just wonder what advice you might give both the lawyers and then the broader citizens here in our own lives going forward, and perhaps some of us here who have broader influence, in terms of engaging today in an era of the Taliban and these movements of extremism in various parts of the world that don't seem to accept the fundamental premise of the liberal, tolerant tradition, which is a right to mutual coexistence.
That is true, and of course that is a dilemma that all democracies face. But actually it was Winston Churchill who in the 1930s said, it will be a very sad day if democracies, in defending democracy, join in making our country a place without the rules that are necessary for a democracy. In some ways it's harder for democracies to fight intolerant people. And fighting the Taliban in Australia would be different from fighting the Taliban in Afghanistan. I have to say as a footnote, as somebody who, as the President said, has driven through the Khyber Pass, or at least I have to give credit, my partner Johan drove through the Khyber Pass 3 times. No one has ever conquered Afghanistan. The British, at the zenith of their power, fought 5 Afghan wars, and in the last of them, the Afghanis sent 1 survivor back to tell the tale of the horror of their onslaught and slaughter. They are a very robust and independent-minded and different people, and we have to really appreciate that, and we have to appreciate that Britain in its power and the Soviets in their power could not conquer Afghanistan. And it's a very beautiful country to drive through, or it was in that window of opportunity in the 1970s, early 70s. But I wouldn't want to be there now. But what can we do? Well, I think we can do what everybody's doing tonight. You can be joiners. I'm a joiner. I've always been a joiner. I got my ASIO file the other day. It was very interesting. I got it because I sent all my papers to the National Archives, and they said, somebody has just sought your ASIO file, we're bound to give it, would you like a copy? So I said, sure. And I got a copy of the ASIO. All those student meetings I attended, they were all faithfully recorded. You're probably down in some meeting, Rocher. It's faithfully and carefully recorded. Certainly many of the groups at these tables are down in the file. And one of the file notes was from my Auntie Glory. She'd actually been born Violet, but she rather liked Gloria Swanson in the 1930s, so she took the name of Gloria. A very intelligent woman. And Sir Lawrence, a friend of your wonderful mother, Jessie Street. She was a feminist in the early days, and she was under surveillance, probably because she had some communist friends. And in her unguarded and rather unkind remark that was recorded there for me to read, she said, Michael Kirby is very brainy, but he is a complete reactionary. It's amazing what you see, home truths coming out in ASIO files. But don't get put off by that. It's a free country. Join, involve, be involved, and be like those pro bono lawyers and the government lawyers involved in the cases, important matters, and try to assist to make our society a place of diverse opinions and diverse expression of opinion. Any other questions or comments?
Thank you, Michael. Mary Kostakidis, Human Rights Consultation Committee. The main criticism, Michael, that we're hearing of the Bill of Rights is that it is going to transfer power from the Parliament to unelected judges, and that this would be a very bad thing for democracy. A penny for your thoughts.
Thank you very much, Mary, and thank you for the work that you and your committee are doing on this consultation. I think that there are dangers in some bills of rights in having a power in courts to strike down measures and to declare them to be unconstitutional. But the only model that is on the table, as far as I have seen in Australia, is a model which was derived from New Zealand via the United Kingdom and now in 2 jurisdictions of Australia, the ACT and the state of Victoria. And it's a model which essentially has 2 principles. First, that courts should strive as far as possible to interpret laws so that they do not breach the principles of the Charter of Rights. Well, now that's not very different from what I've just been telling you we already do, and what the common law has always done, and what the great early justices of the High Court of Australia, Justice O'Connor, in the Jumbunna case, said at the very beginning of our federation that we should do. Make sure that Parliament doesn't accidentally take away fundamental rights. Read statutes with that proposition. So that's not really controversial or new. And secondly, it empowers the court in the event that Parliament has been so clear that it can't read the provision down, as the majority felt in Mr. AlKhatib's case, to draw that disparity specifically to the notice of Parliament by an order of a declaration or some other means, in order that then Parliament has to particularly and specifically address its attention. Parliament might then say, we won't change the law. Parliament might say, well, that is exactly what we intended, operating it and enhancing it and ensuring as far as we can that Parliament addresses issues. I can tell you from 10 years in the Law Reform Commission and many years as a judge that the problem is often not that Parliament decides not to do something, but just that in the press of events, and of the press particularly of political events, and the events to which media draw the politicians' attention, that the little cases and the little people sometimes get overlooked. And that isn't something which makes Parliament work as at least I conceive Parliament should work. Any other questions?
Under the present, for want of a better word, Constitution of the United Nations, do you see that international law will work well under those present circumstances, or will remain very political?
Well, my experience in the United Nations has not been in the political departments. I've had virtually nothing to do with the General Assembly or the Security Council. That's for the politicians. But I have been involved in the International Labour Organisation, in the World Health Organisation, in the UNAIDS Organisation, in the UNDP, the Development Programme, in UNODC, the Office of Drugs and Crime, in lots of these committees. And they are made up of truly noble people who do wonderful work. Of course, there are defects in that institution as there are in the others. But if the United Nations did not exist, we would have to invent it. We would have to have an international forum in which people could exchange knowledge, views, expertise and principle. And I think, therefore, I'm a supporter of the United Nations. And I think educated people should be, because the alternative is a world in which it's simply the rule of power. And unalloyed power can sometimes not be rational. I may be wrong, but I think the 2 special features of the human species, which are interconnected, which lie at the heart of human rights, are, first of all, we have a genetic propensity to rationality. We don't always give effect to it, but we have this propensity to think about ourselves and to think about where the world is going, and our community, our families, our loved ones, and others. And secondly, we have a propensity to love one another. This might be a semi-spiritual and controversial suggestion, but I've always thought that the foundation of human rights is that we can express and respect human rights for other people because we can see in them enough of ourselves and our families that we feel we share this space and this existence with them. And that is love. And if you're religious, you know that the greatest of these is love. And if you're secular, you at least know that we have to build our world again upon human rights, because the alternative is the eradication of our species. There are just so many dangerous weapons and so many dangerous people that we need to unite around core principles. And the greatest of these is love.